Hello everyone, welcome to Samvidhi classes. This is Neha and I am going to take you all on a tour of learning law of torts with me. In my session, I'll be dividing the topics of law of tort into several subtopics so that slowly and gradually you are thorough with the subject. Moving on with the session, I would be discussing the meaning and the nature of tort, how is tort different from crime, how is tort different from contract, and what are the essentials for the tortious liability. Let's discuss what is tort. The word tort has been borrowed from the Latin word tortum, which means crooked, twisted, or wrong. In simple language, if we have to discuss or define wrong, we would simply say something which is inappropriate, incorrect, or something which is not right. But for the legal language, we have to keep in mind the phrase breach of duty. How does this breach of duty happen? Breach of duty arises upon some act or some omission. Now, this act and omission is recognized through criminal laws such as BNS, contractual laws such as ICA, or law of torts. Upon such act or omission, there will be some damage, and whenever a damage happens, the aggrieved party gets a cause of action. It simply means the aggrieved party has right to sue. Let me tell you that there are two parties to the suit. One is the plaintiff and the other one is the defendant. The plaintiff is the person who has suffered the damage and instituted the suit. And the person who has been sued is called as the defendant. This is one concept to be understood. The other concept is types of wrong. There are two types of wrong. One is public wrong and the other is private wrong. So, public wrong is something which is against the society at large. And private wrong is something which is against the individual. In same line, we can say that tort is a civil wrong, because it only affects the individuals. Let's take some example. Suppose A slaps B and A murders B. In the first example, where A is slapping B, the aggrieved party or the only party which is being affected is B, and since B is having right to sue, he will be called as plaintiff, and this is a civil or a private wrong. Fine. Unlike in this example where A murders B, the act of A affects the society at large. The wrong that A has done is not only against B but at the society at large. Therefore, this is a public wrong. So, to summarize, we can say any act or an omission which is deviation from straight or right conduct could be termed as a tort. Let's figure out the difference between the tort and a contract. Under a contract, duty is imposed by law. Which law? Tort law. And the person whose right has been infringed is only the person who can sue. Let's go back to the example of A slapping B. The right to sue was only available to B and no one else could have sued A. The damages in tort is unliquidated, which means it is left for the court to decide what liability will A have after slapping B. Fine. Coming to contract, the duty is imposed by the parties. The parties themselves, by entering into the contract, before only they lay down the rules that they need to abide by. And in violation of those rules or terms of the contract, they can be sued and sue, which means privity. Privity simply is a concept that means the right to sue and be sued is available to the parties to the contract. Parties to the contract themselves decide what damages are they going to give to the aggrieved party in the violation of the terms of the contract. Fine? Let's have a look on the essentials for tortious liability. There has to be certain act or an omission, and due to that act or omission, legal damage has to be caused. So the essentials are act or omission and legal damage. Moving on to discuss two very famous legal maxims, which are injuria sine damno and damnum sine injuria. Injuria sine damno means violation of a legal right of a person without causing him any loss or damage. Let's take the example of SB versus White. What happened here was, SB went to the polling booth to cast his vote, but he was stopped by the police constable. Later on, it was found that the candidate for whom SB wanted to vote won the elections. Therefore, no damage was caused to SB. Fine. So this is the concept of injuria sine damno, which means violation of a legal right without causing any damage. Let's discuss the other maxim, that is damnum sine injuria, which means damage without legal injury. In order to understand this, we will be taking a look to the Gloucester Grammar School case, wherein there was a school A already functioning well in the locality, and employee from school A, B, opens up a new school in the locality, due to which financial losses were incurred to school A. The owner of the school A sues B for the financial losses. The court in this case held that though there is a damage, but it is not a legal injury. Therefore, there was no liability being imposed on B. That's it for today's session. I hope that you are thorough with the concept, whatever I have dealt in today's session.